Here is a summary of the May 6, 2025 Supreme Court order in the case called United States et al. Versus Shilling, Commander et al., case number 24A1030. The question presented in this order is whether the Supreme Court should stay the nationwide injunction issued by the United States District Court for the Western District of Washington. Here is the text of the emergency docket order. The application for stay presented to Justice Kagan and by her referred to the court is granted. The March 27, 2025 preliminary injunction entered by the United States District Court for the Western District of Washington, case number 2:25-CV-241 is stayed, pending the disposition of the appeal in the United States Court of Appeals for the Ninth Circuit and disposition of a petition for a writ of certiorari, if such a writ is timely sought. Should certiorari be denied, the stay shall terminate automatically. In the event certiorari is granted, the stay shall terminate upon the sending down of the judgment of this court. That was the text of the emergency docket order. The order was unsigned. Justice Sotomayor, Justice Kagan, and Justice Jackson would deny the application. In plain English, this order means that the District Court's nationwide injunction is on hold until final adjudication of the case on the merits. The District Court's nationwide injunction prohibited the Department of Defense from implementing a policy that generally disqualifies from military service individuals who have gender dysphoria or who have undergone medical interventions for gender dysphoria. Here is a summary of the government's application. In February 2025, the Department of Defense adopted its current policy, which generally disqualifies from the military service individuals who have gender dysphoria or who have undergone medical interventions for gender dysphoria. The policy was based in part on the findings of a panel of experts convened during the first Trump administration, which found that service by individuals with gender dysphoria was contrary to the military effectiveness and lethality. Respondents are 7 trans-identifying individuals who are currently serving in the military, 1 trans-identifying individual who wishes to join the military, and an advocacy organization whose members include 3 of the individual respondents. On March 27, 2025, the District Court granted respondents' motion and entered a nationwide preliminary injunction, prohibiting the government from implementing Executive Order Number 14,183 and the 2025 policy and requiring the government to maintain the previously existing policy. Agreeing with respondents' characterization of the 2025 policy as a de facto blanket prohibition on transgender service, the court held that the respondents were likely to cede on their equal protection claim. The court concluded that the 2025 policy was subject to intermediate scrutiny because the policy discriminated based on transgender status and sex. The court further concluded that the 2025 policy failed intermediate scrutiny because, quote, banning transgender persons from serving was not substantially related to achieving military readiness, to achieving unit cohesion, good order, or discipline, or to cost effectiveness. The court also held that the 2025 policy would not survive rational basis review because the 2025 policy relied on 7-year-old predictions without citing updated data. The court likewise held that respondents were likely to succeed on their First Amendment procedural due process and equitable estoppel claims, and it concluded that the respondents satisfied the remaining preliminary injunction factors. The court denied the government's request for a stay. The government appealed and asked the Ninth Circuit for an administrative stay and a stay pending appeal. On March 21, 2025, the Ninth Circuit denied the government's request for an administrative stay. On April 18, 2025, the Ninth Circuit issued a 1-page order denying the government's request for a stay pending appeal. the court stated that the government had not shown that it will suffer irreparable harm absent a stay. On April 24, 2025, the government filed an application for stay of the district court injunction with the United States Supreme Court. In the application, the government argued that the 2025 policy does not discriminate against any suspect or quasi-suspect class. Instead, the 2025 policy draws classifications based on a medical condition and related medical interventions. Thus, especially given the military context, the 2025 policy warrants only rational basis review, which the government claims that it easily satisfies. The government claims that the 2025 policy satisfies the deferential standard of rational basis review. The government has undisputably important interests in maintaining military readiness, cohesion, good order, and discipline, as well as managing the military's costs. The 2025 policy is rationally related to achieving those ends. The 2025 policy requires current service members who have never been diagnosed with gender dysphoria and who have never received related medical interventions to serve in their sex and to meet the standards and requirements applicable to their sex. Respondents claim that the policy violates the First Amendment because it prohibits transgender people from disclosing that they are transgender or expressing a gender identity that is different from their sex assigned at birth. But the 2025 policy does not prohibit transgender people from disclosing that they are transgender. Nothing in the policy turns on a person's identity, let alone whether a person discloses a particular identity. The policy does not. The respondents also contend that the 2025 policy violates the First Amendment by requiring the use of pronouns that reflect a service member's sex. But within the military community, there is simply not the same individual autonomy as there is in the larger civilian community. The policy on pronoun use is merely one of many protocols governing how service members should be addressed within the military community. The First Amendment does not stand in the way of such efforts to maintain good order and discipline within military ranks. The respondents' claims about procedural due process, equitable estoppel also fail. Even setting aside the district court's errors on the merits, the court improperly enjoined the 2025 policy on a universal basis. The court should have limited any injunction to the 8 individual respondents in the case. Nationwide or universal remedies exceed the power of Article 3 courts, conflict with longstanding limits on equitable relief, and impose a severe toll on the federal court system. Article 3 does not empower federal courts to exercise general legal oversight of the legislative and executive branches. To reach beyond the litigants and to enjoin the executive branch's action towards third parties would be not to decide a judicial controversy, but to assume a position of authority over the governmental acts of another and co-equal department in authority which plainly courts do not possess. Universal injunctions also contravene this court's precedents on Article 3 standing. Standing is not dispensed in gross, so plaintiffs must establish standing for each form of relief that they seek. Universal injunctions also transgress restrictions on courts' equitable powers. Federal courts sitting in equity must apply traditional principles of equity jurisdiction and may award only those remedies that were traditionally accorded by courts of equity. Congress may, by statute, authorize new remedies, but courts may not on their own authority create remedies previously unknown to equity jurisprudence. American courts of equity traditionally did not provide relief beyond the parties to the case. In staying the injunctions against the 2025 policy, the court needlessly issued a nationwide injunction. this was improper. The government will succeed on the merits to the claim, which is a crucial factor determining that the government's application should be granted. The other stay factors, i.e. whether the underlying issues warrant review, whether the government likely faces irreparable harm, and the balance of equities, support the relief requested here.